Ray Austin, County Attorney Jill Gillette appearing for the state, Mr. Austin appearing in person, and pro se. Mr. Austin, you are here for first appearance. The state alleges in count 1 that you committed domestic battery. Specifically, the state is saying that you on or about December 22nd of 2025 in Greenwood County did unlawfully and knowingly cause physical contact with a person with whom you were involved or had been involved in a dating relationship or was a family or household member, to wit, Shauna Weigel, when done in a rude, insulting, or angry manner. So they're saying you had physical contact done in a rude, insulting, or angry manner with Shauna Weigel, who was in a dating relationship or some kind of family or household membership. This is charged as a B person misdemeanor. Penalty could be up to 6 months in jail and a $1,000 fine. Actually, with that being domestic battery, there are other penalties that if you do not get a certified domestic batterer's evaluation, you could pay there could be a fine. I believe that's a mandatory $250, and you could have to serve 48 hours in jail and the rest of it on probation. But the fine and the jail time could be waived with an evaluation. But overall, an A misdemeanor is up to a year in jail and $2,500 in fines. But there is some mandatory must serve and must pay if convicted. So, Mr. Austin, are you going to hire an attorney, apply for court appointed, or waive attorney and represent yourself?
Studio microphone clip 1. What we've just witnessed is a first court appearance for the defendant, Mr. Austin, who has chosen to represent himself, what the court calls proceeding pro se. He is facing 2 misdemeanor charges. The first is domestic battery, based on allegations that he made physical contact in a rude or angry manner with someone he had a personal relationship with. The second, more serious charge is criminal restraint, accusing him of unlawfully restricting that person's freedom. Both charges carry potential jail time, fines, and mandatory conditions if convicted. Despite these risks, Mr. Austin declines legal representation. And as the hearing continues, that decision begins to shape everything that follows.
Pro se.
You don't want to hire or apply for court appointed?
No, ma'am.
Pro se meaning you want to waive your right to attorney and represent yourself?
At this time, yes.
You want to do that even though there is some potential mandatory jail time?
Yes, ma'am.
You understand you do have the right to either hire or apply.
I may consult with one later on, but at this time I would like to just enter pro se.
All right, and how do you want to plead pro se? You want to plead not guilty and set this for trial at a later date? I need to also tell you there's count 2, criminal restraint. They're alleging that you unlawfully and knowingly without a legal authority restrained the other person, the same person, and you did so to interfere substantially with her liberty. Now, that's a Class A person misdemeanor. That penalty could be up to a year in the county jail and a $2,500 fine. So you have 2 pretty serious misdemeanors. Are you sure you don't want to talk to an attorney? Hire or apply anyway?
Not at this time, ma'am.
All right. Well, I'm going to show that you're knowingly and voluntarily waiving your right to an attorney. Is anyone making you waive your attorney?
No, ma'am.
All right, then I'll have the journal entry and the docket notes indicate that you're knowingly and voluntarily waiving your right to counsel on the record. And at the next hearing, I want you to be here in person so I can, if you still want to waive, I want you to sign a waiver as well. If you get out there looking for an attorney and you find that they are pretty expensive, you can come back to the courthouse and ask for a written application and put all your information in that and get that to me. But don't put that off until right before trial. Make sure I get that in time to, if I'm going to make an appointment, to make sure you get it in time to be of value to you at your next hearing.
Okay.
But some people don't like all their financials over the internet, and I can appreciate that. And that's why I say, if that is a part of the consideration, come to the courthouse, get an application.
Yes, ma'am.
All righty. Now then, Missy, when's his next court date?
We can set it for status April 28th at 3:30.
All right, April 28th at 3:30. You and your attorney must be back here. And I'm going to have you come to the courthouse if you don't have an attorney. And then, because like I said, I'm going to either have an appoint one or I'm going to have you sign a waiver if you come here without an attorney, because I want to make sure that we cover on the record that you know you've got the right to an attorney and that we can help appoint one if you qualify.
Okay.
All right. So be back here April 28th at 3:30. And let's look and see if you have a bond.
The most significant moment comes when Mr. Austin asks the court to lift the no-contact order with the alleged victim. He argues that she is not afraid of him and has even submitted a statement supporting that position. He also claims the restriction is creating hardship for her, as she has no support system nearby. But the judge's response is firm. In cases involving domestic allegations, no-contact orders are not based solely on the victim's wishes. They are protective measures imposed by the court to prevent escalation and ensure safety during the legal process. The judge also appears concerned that Mr. Austin may already have had indirect communication, raising questions about compliance. This moment highlights the tension between personal claims and legal safeguards.
Looks like there was a $1,500 cash or surety bond posted with Florio on February 18th. I will continue that and make sure that you understand I'm adding, if it's not already there, a no contact order with that person that is alleged to be your victim.
If I may, Your Honor.
Yes.
It was a $15,000 bond.
Yes. What did I say? 1,500?
Yeah. And
yeah, 15,000.
If I could see that, I was hoping to see that maybe the court would see to lift the no contact order. Ms. Weigel has submitted an affidavit saying that she does not fear me and there is no problems. I don't have any prior record of domestics. And she's not from around here. So it's kind of created a pretty good hardship for her. She's from Oregon. She don't have family here. I'm the only one that she really knows here. So we would like to see, or I would like to see if we could get the no contact order lifted.
Well, Mr. Austin, it sounds like the two of you have been having contact, and I'm going to order that you not have contact, even whether it's a condition of your bond. She's not to call the jail. You're not to call her. No contact until I hear otherwise. Now, if she's listening, she can always contact Miss Gillette at the county attorney's office, and they can talk and decide if the state wants to modify that. You can talk to your attorney about it. But at this point, I'm not going to, because of the nature of the charge, I'm not going to modify the bond.
Okay. And for the record, we haven't had contact. She filed this the day that I was arrested, or tried to file it, and it was, apparently the record was sealed. So I just know.
Well, you were talking like that. Maybe you knew what she wanted, so I assume the only way you'd know that is if you communicated with her. But whatever's happened to date, I'm not going to get too worried about, other than from this point forward. It is specifically a condition of your bond. It's also a condition of the court's order that you have no contact.
Yes, ma'am.
All right. So thank you, sir. Ms. Gillette, anything further?
Nothing further from the state.
Your Honor,
Yes, sir.
I've also filed for discovery, and I would like to see if we couldn't get that produced.
Well,
There will be, we have your request because it was filed in the case. There will be a cost because there's a cost for discovery, and it'll have to be printed for you. You'll need to come up, and we'll have to get all of it prepared and give you the estimated cost so that you can get that here, and then it'll be given to you.
And generally, discovery is given to the attorney. So if you're going to have an attorney, you'll need to either have the attorney get it for you, or if you get it, the attorney's going to have to be satisfied with what you have, or he may end up having to pay for it again if you're both going to have official copies of it. So I would suggest you talk to your attorney before you pursue discovery any further, but that's your call to make. You may want to continue to represent yourself. You said you want to go pro se, and if you do, you can get your own discovery.
Yes, please, if I could.
Well, that's between you and the state. And if she doesn't give it to you voluntarily, which she generally does, she may make you file a motion, and that's procedure. File a motion for discovery, and if you
I have about 30 days ago, and
all right, well, as long as you know how to represent yourself, you're welcome to do that. Otherwise, it would probably be in your interest to get an attorney. But that's your call to make, sir. You are entitled to discovery, whether it's through you or through an attorney.
could I get the state or the court to set a deadline for discovery?
Ms. Gillette, has he filed the motion already? You said you've received it.
Yes, there's a motion. We just needed to know if he was going to have counsel or not, and this is his first appearance. So since he's not wanting counsel, then we'll send him how much the discovery is so that he can come in and get it.
All right. Well, I'm asking that the journal entry and the docket notes again reflect that he's knowingly and voluntarily waived his right to counsel, and I'm ordering him to appear in person at the next hearing so I can have him sign that in writing. But it's still going to be binding on you until you tell me otherwise. You can always change your mind, Mr. Austin.
Yes, ma'am.
All right. So setting a deadline, when can you have that for him, Miss Gillette?
Sherry will be in tomorrow, so she'll have the cost added up tomorrow. So you could probably get it maybe Friday.
Right. I'll say that, how about if I say you can have up to 7 days after he's paid the fee for discovery, Miss Gillette? Will that work?
That'll work, Your Honor.
That'll be the order. After you get the discovery money to her, then she has 7 days to get you what you're asking for.
Yes, ma'am.
All right. Thank you, sir. Anything else?
That's it.
All right. Then you're excused at this time, Mr. Austin. You may go.
By the end of the hearing, the judge does not issue a final sentence, because this is not a trial but an initial appearance. Instead, the court focuses on procedure and control. The bond remains in place, the no-contact order is enforced, and a clear deadline is set for the exchange of evidence, known as discovery. The judge also takes extra steps to document that Mr. Austin is knowingly waiving his right to an attorney, an important legal safeguard. In simple terms, the court is ensuring that the case moves forward fairly, while minimizing risk to all parties involved. And as the hearing closes, one thing is clear. The legal process has only just begun, and Mr. Austin will be navigating it on his own.